Welcome to Healthcare Legally Speaking. I'm here with
Michael Mueller.
Michael. Tell us, what do you do?
My law firm, the Mueller Law Firm, practices exclusively in family law and in divorce law. I was admitted in April of 2011, and I've been practicing here since then. So we're now in our 14th year of practice representing families in New York City and primarily in Brooklyn and Manhattan courts.
That's great. That's great. And listen, I appreciate you coming down here to our offices to sit down and have this chat. One of the reasons I wanted to bring you here and have this conversation is that we are healthcare, legally speaking. So it's focusing a lot on the healthcare professionals. That's what I'm trying to lead this podcast to be about. So a lot of concerns for medical professionals, doctors, other people in the healthcare space is what happens in marriage, right? That's a big concern we all have. In the beginning, if a young doctor or someone that's about to get married, what are some of the considerations in terms of their ability to practice, in terms of some of their assets? And we'll go through it because oftentimes, doctor, when they come into a marriage, especially I personally as a lawyer, when I came to my marriage, I was saddled with debt, right? You got the medical school debt, in my case, of course, and probably yours as well, the law school debt. Talk to me about what are some considerations that doctors need to worry about when they're thinking about getting married?
So when doctors or the fiancés of doctors speak to me prior to marriage, we primarily talk about doing a prenuptial agreement, which would define certain terms, whatever they agree to, as little or as many as they want, that in the unfortunate event of a divorce, those would be decided. And some people do put terms in prenuptial agreement about some expectations during the marriage, but I am highly against that. I don't think you should be living your marriage by directions. If the things aren't working out in your marriage, you can fix them. If not, you should go get a divorce. When I'm looking at a prenup, we look at it in reverse. We look about what would happen in a divorce. So the issues that could be in a prenup and the ones that you'll need to deal with in a divorce are the distribution of your assets, the allocation of your debts, deciding which debts and assets are marital that are subject to allocation and distribution, or which are separate or premarital and are not. You are also most likely in a relationship between a doctor and a lower salaried spouse. You're going to be dealing with alimony or maintenance. And finally, the two last categories that don't encourage people to put into an agreement are child support and custody. The reason being, although they could put them into a postnuptial agreement, they're not fully enforceable. Anything to do with the children, when you get to court, the judge can review, and it makes sense. If you put in a child custody term in a postnup and you get divorced 15 years later, who says 15 years later that the chosen person is still the best custodian for the parent, or that the child support terms you decided 15 years ago are fair for the child? So when it comes to the child, I encourage people not to put them in. And if they do, I just make sure that they're aware that they may not be enforceable. So that's the beginning of the conversation, just the broadest strokes for anybody. Specifically as it relates to doctors, there are certain assets that doctors will own during their lifetime that are a little more complicated for distribution. And lawyers have the same issues. For instance, a non-lawyer can't own a law firm. And I'm not an expert on all licensure in New York State or other states, but from my experience, there are businesses that cannot be transferred into the control of a non-licensed doctor. So first and foremost, I let people know that, because from experience also, during the marriage, doctors, in addition to their own practice, tend to invest in other medical businesses. And I've just seen it a lot, and it makes sense. It's their expertise. And some of these businesses some of them may only be able to be owned by a doctor, or some of them, the doctor may lend his licensure and be a part-time employee, which makes it hard. Or it might be a closed LLC with a few doctors, or the doctor may even be providing services to LLC. So it's not that simple. We can't just transfer during the course of a divorce or in a prenup 10 units of an LLC that's owned by a doctor to the spouse. So I try to let people know in advance you're going to run into a problem.
So I guess let's peel back the onion here, right?
Sure.
Because there's tons of layers. Let's look in the beginning. The doctors would need to know in terms of if they get married and then they're going through a divorce, does the spouse have any kind of right to the revenue generated by the medical license?
The answer is yes. It used to be that the license itself could be valued and that the license itself was called enhanced earning capacity. and the license itself will be distributed. The lowest change, I believe, is 2016. And it makes sense because the value that the spouse will get will be based on a licensed business, which of course has value from the medical license, but the license isn't carved out and valuated. But yes, the doctor's business is subject to equitable distribution based on the same principles as any other business. So if he did not have the business when he wasn't married, but he started his practice during the marriage, half of the doctor's share of the business is marital. And that's when we actually become, one of the problems is when the doctors have 10 partners, right? It's hard. It might not be that the doctor can divest of his shares. So what I tell people is that make sure there's money somewhere else. I don't need a doctor to sell his shares or sell his business, particularly where there's no market for a closed corporation or small LLC. So that's what I tell them. Don't put all your eggs in one basket. Make sure there's other money available that in the case of a divorce, you can provide for your spouse. Alternatively, and I've done these prenups, you can put in the prenup that the non-doctor spouse waives all equitable distribution of any certain number of assets. That's perfectly enforceable so long as the spouse is aware which he or she is signing. Of course, in these situations, I almost insist that the other party has an attorney because they are certainly giving up a lot of rights. But that's another way to protect doctors is in the prenup is for the other party to waive their rights and either waive your right completely to equitable distribution of marital assets. You can waive them just as it relates to the medical practice. You can, or let's say a doctor had a medical practice that pre-existed the marriage. You can carve out that one practice and say, this is a separate asset. Any appreciation of the asset is not subject to any equitable distribution, but maybe the 10 other small LLCs I invest in during that marriage will do. And those are questions I try to let, particularly people rather get married when they love each other. I try to give them the broadest picture. I never tell someone, hey, you should cut out your spouse or that you should give your spouse everything, I should say. And if you're not going to limit your spouse's rights, so what we really want to do is just identify the assets. Identify like I said, this asset is separate. This is not subject to equitable distribution. This is. And then the other category, and this comes from the business, is the alimony. So you can, like waiving your right to equitable distribution of an asset, you can waive your right to alimony. So let's say you waive your right to the equity in the business. You may also choose to waive your right to alimony. The mathematical formula, I won't get into it, but you take the higher salary spouse, you take the lower salary spouse, you do a portion of the higher salary spouse and a portion of the lower salary spouse, and you subtract the two. When I'm doing napkin math in the office, I just tell people without doing calculation, let's take a third of the delta between the two and see what it is. And that's a good start. But there's specific statutory formulas. So if you don't waive alimony, you will get your alimony from the business that you waived your rights into. Alimony does have caps in New York State. I believe the cap on alimony is roughly $228,000 right now. And what that means is that initially a court will only look at the first $228,000 of combined income when determining alimony. However, the court can exceed the cap. And when you upstate New York, probably less likely to exceed the cap. But certainly in Brooklyn and Manhattan, where I predominantly practice, they will exceed the cap.
Just to clarify on cap, what does that mean? Does that mean that they only look at $228,000 and figure out who owes part of that and decide on alimony?
So what they do is they take both spouses' amounts of income, and they figure out what proportion of the total pie, the total income each one makes. This is your marital income. Then so let's say the doctor makes 90% and the non-doctor makes 10%. And let's say the combined income is $2 million, whatever it is. They're going to look at the first 228. So they're going to say the doctor's portion the non-doctor's portion is roughly 22,000 and the doctor's portion is roughly 200,000. And they're going to use those two numbers to determine alimony.
How do they determine? So for example, a family makes $1 million.
Let me explain. So first they look up to the cap. They say, we're not worried about above the cap money. This is what you're entitled to under the cap. Then they say, you know what? Based on whatever your circumstances are, we're going to go over the cap. in my experience, never going to go all the way to the top for every last dollar. But the higher you are above the cap, the higher the cap will go. In my last case, where there was about $1 million in income, based on my reading of case law and my motions, we got the cap up to 750. So they were looking at the first $750,000 of combined income, even though the combined income was at 1.2, 1.3. And I felt that was fair based on my reading of the law. Whether my client thought it was fair, I don't know, but it was.
Let's say a couple makes $1 million, right?
Okay.
One partner makes 700,000, the other 300,000, right?
Yeah.
So how do you tell at what point who contributes what to, if it's not to the total million that you're looking at? If you're
looking at their proportion at all times. So if you're looking at the cap of 228, you're saying that the higher salary spouse in your hypothetical makes 70% of the 228 and she makes 30%. And they basically pretend this is what we're going to do. But like I said, you can exceed the cap. There's a lot of factors that exceed the cap. Well, the reason they exceed the cap often in Brooklyn, Manhattan is it's really expensive to live in Brooklyn, Manhattan. And also could look at the lifestyle of the parties and what's fair and what they've been spending throughout the marriage. So they often exceed it. And it's usually a big fight in these situations of how high are we going to go over the cap.
Now, let's go back a little bit.
Yeah.
What difference does the scenario make if, for example, a medical professional is licensed prior to marriage versus obtaining the license during the marriage? Does that play a role? Does that make a difference?
It really wouldn't. The license, no, it really wouldn't. Because it's really about the business. But I'll say this, if he was licensed and started a practice, like you own his practice before the marriage, that you could say is separate property. But since we're not really evaluating the license for distribution, it's just benefiting everyone in other ways. It really, if you got it before the marriage, there would be more, in theory, of business and also more money. Any money that you have before the marriage is separate by law. So that's really the distinction.
So how is debt treated? So we're all saddled with debt immediately when we start practicing. Doctors go to residence and fellowships where they're not making all that much money. How are those things treated? How is debt treated in terms of when you're thinking of a split or in putting it into a prenup?
The general rules are your debt before the marriage is separate debt, period, end of story. And the debt acquired during the marriage, regardless of whose name. I have my own credit card. My spouse has a different one. I spend $100,000. She spends nothing. That $100,000 on my card is still a joint debt. Now, there are exceptions if I'm spending the money on things that are non-marital. Maybe I'm spending money paying off my premarital debts. Maybe I'm spending money on some more illicit things like gambling, or maybe, God forbid, there's adultery. Those things, of course, those are not marital debts, marital expenses. But generally, your debt during the marriage is marital and they were subject to allocation. Hopefully, before the marriage is done, we can also just pay the debts off so that when they, instead of just putting it in agreement, so they can start fresh. But that's the general point. So the student loans that are huge and that they have are going to usually be separate debt. But, and this is a little callous, when I hear from lawyers and doctors about their student loans, the ones that I speak to are making a lot of money, and it would seem like it was always a very worthwhile investment. Anyone could do simple math of what they'd be making minus the student loans and minus their income. So they are huge, large amounts of money, but they're usually manageable and they're really a benefit to both parties.
Fair enough.
But look, no one wants to pay $500,000 in loans. I get it. But over the lifetime of your practice, you're going to benefit greatly. So we do have to deal with it, but that's just my own personal.
Sure. So I guess now that we're going through the happy marital phase and all that stuff, difficult conversation to bring up is, hey, let's get a prenup done. Can you give me some examples where, let's start with, it doesn't make sense to get a prenup for a medical professional?
It always makes sense to get a prenup. Unless, of course, you are even as a medical professional, I suppose if you're marrying someone that makes millions of dollars a year, much more than you, it would be financially irresponsible of you to say, I want a prenup and cut it off. So we're really looking at it that way. As an investment in your future, yeah. If you are the much lower salaried spouse and the other person has a lot of assets and they're going to acquire a lot of assets during the marriage, yeah, you're better off with no prenup. That's really the only scenario. Now, even in that scenario, when you end up going to court in 10 years for your divorce, you're going to have some issues and you spend a lot of money on legal fees, which are a marital debt. So regardless of who's paying them, you're just depleting funds. But yes, the much lower salaried spouse is not always financially responsible for them to waive all their rights or any of their rights to alimony or the distribution of debts. What I tell people then, and this is how I start all my prenup conversations, I say, this is what the law says. Well, let's start there. The law says that the things you have right now are separate. The law says that when you get married, the assets that are acquired during marriage are going to be distributed. The law also says at whatever point you get divorced, the court will look at each party's income to determine alimony. And you can do a prenup that mirrors the law. And the purpose of the prenup is just to make clear what the separate debts are. Because we go to trial 10, 15 years later after a person's married, and they're saying, I brought in $1 million into the marriage, but my bank only has records going back 7 years. So that's another headache and fight. If it's clear in your papers, so we're going to follow the DRL, the domestic relations law, but this is separate. And then we can work from there. Even though this would be normal, let's carve out this. Let's carve out all the medical practices. Or if it's two working people who have similar incomes, a lot of times they come to me and they're the first things they want to waive is alimony. Because they're like, and the other thing, and I have my notes here, just this is a very big misconception by a lot of people. There's no such thing as that lifetime alimony in New York. I won't speak about other states. And with the exception of, I suppose, if you got divorced after a long marriage when you're 75, it might stay with you until you pass away. But there's no lifetime alimony. So the length of time that the higher salary spouse would pay to the lower salary spouse for alimony is prescribed in the law. So for instance, for a marriage for up to 15 years, the law says that alimony will last 15% to 30% of the length of the marriage. Now that is certainly a range. For a hypothetical 10-year marriage, your alimony payments are going to be for 1.5 years to 3 years. And they may be significant if you're paying, let's say your spouse stayed at home raising kids and they're making $1 million a year. They'll be significant, but they'll be for 3 years. And it does go up. For a marriage of 15 to 20 years, you're paying 30% to 40% of the length of the marriage. But the point is, in all scenarios, even at a 20-year marriage, we're looking at 6 to 8 years of alimony. It's not, people are always nervous. I'm going to pay the rest of my life. You're not going to pay for the rest of your life. And in these ranges, this is not the law. The court has a lot of factors, but oftentimes we split the date. So if it's 15 to 30%, we'll say, okay, 22.5%. And then it's just fair. But this is something that's a big misconception. People think it's going to be forever. How am I going to pay it? So that's something, one of the few pieces of good news I get to tell people when they come in to consult for divorce.
That's certainly good news.
Or sometimes it's bad news. Sometimes the lower salary spouse, I have to tell them, unfortunately, sir, you have to go back out into the workforce. Your alimony is only going to last as long. And even with the alimony, something I tell everyone, no matter how much alimony you get, you'll get more money if you work. And even if people will, leading up to a divorce, not work on purpose because they want to increase their alimony, if you do math, for every dollar you make in the workforce, even if your alimony goes down 20 cents, you're still going to have more money. And this is a constant thing I have with a lot of clients, that they make the bad decision, like, I'm not going to work right now. You always should have an extra source of income.
Fair enough. Let me ask you this. What do you tell to those that say, when you plan for failure, you plan to fail?
Kind of wrong. Failure to plan is planning to fail, right?
But I'm talking about, like, when you have a plan for,
Oh, I see what you're saying.
you see what I'm saying? Like, basically, by getting a prenup, the theory is you're planning for a divorce.
Well, I always tell my clients, stick this in a drawer. Don't look at it again until you're ready to hire me for your divorce. There's nothing wrong with knowing with certainty what's going to happen if you get divorced. And there's a lot of misconceptions out there. There are prenups that could encourage a divorce because you're getting X. I will talk about Donald Trump's prenup. He had some interesting ones. I think Michael Douglas and Catherine Zeta-Jones had an interesting one where the spouses were provided certain amounts of money for how long they stay in a marriage. But that's not what the average couple here is. And you want to make an analogy. We're providing you health insurance. We're providing you life insurance. We're providing you something that hopefully you won't use and you don't want to use, but you'll be very happy you have it when you use it because you'll be avoiding legal fees. Because a prenup is negotiated when you still love each other. Not going to be as loving when you get a divorce. And the legal fees are a complete waste of money in litigation. You don't recoup them. They just deplete your assets. So I don't think it's planning to fail. I do think most people think it's not romantic. And there are situations where the prenup is sprung on your fiance a week before the marriage. Still perfectly legal. But then I've done them. I had to turn one around, I think, in 48 hours. But in those situations, then I could see that you're starting off on the wrong foot, because then the person signed it not under legal duress, but certainly
Pressure. Absolutely.
pressure.
What you're telling
Yeah.
folks is, and not
Yeah.
put words in your mouth,
Yeah.
but essentially like when you're planning the wedding in the very early stages,
Yeah,
that's when you
because
discuss it.
I'll be honest, a lot of post-ops I do are not contentious, and some of them become contentious, certainly. But especially when you're planning the wedding, you're getting a little crazy. You don't have time for this. But yes, I tell people, they're like, "Oh, we're not getting married for 6 months." I'm like, let's just get your post-op done now. Not that I'm trying to sell my services to you, but trust me, you don't want to be managing the last-minute disasters that happen in a wedding while negotiating anything.
Talk to me about the difference between a prenup, a postnup, and what you're seeing in the medical community.
A postnup is very similar in language to a prenup, which is also very similar in language to a divorce settlement agreement or a stipulation of settlement. The difference that prenup is made in contemplation of marriage, the postnup is made like any contract, if you really want to think about it, although it's governed by DRL. Each party are making mutual exchanges of promises, and there's your consideration. And unfortunately, the reason postnups often come up is because something bad happened in the marriage. Because you can pressure your fiance to potentially sign a prenup, but what is the incentive? Why would the other spouse do the postnup? It does not serve that people. The postnup is going to limit your rights. If you are potentially going to get divorced, you're still better off doing the postnup now. Maybe you don't love each other as much, but you certainly don't hate each other like you loved before. The considerations that happen with doctors are now they have a lot of practices. Now they're one practice. They started with their buddy. Now they got 30 practices in New Jersey, Long Island, and upstate New York. And one of their partners just got divorced, and it was a nightmare. And everyone starts freaking out. Got to do post-up. Got to do post-up. And there's nothing wrong with that. And if you're representing the doctor, obviously you're trying to protect his assets. And if you're representing the spouse, you're fine with protecting the assets. You just want to make sure that the spouse is taken care of some other way, whether it be by alimony, whether it be by other assets of equal value will be provided to the other spouse. There's more complicated ways of doing things. They were going to evaluate the medical business. But I usually try to, let's just look at what's on the paper and let's carve out things that we could have from the non-doctor spouse. That's the way I prefer to do things. And I've seen them. And I've done ones where I've told my client, you're giving up more. If we got divorced tomorrow, you're giving up a lot more than you did divorce. But the spouse wanted to do it, and that's fine. I've had post-ups between two doctors. It can be done. It's better than a divorce. But it usually happens when something either bad happened in the marriage, where I'm heading towards a divorce, but I'll give it a shot if you sign a post-up. This doesn't happen with doctors, but in other cases, maybe there's been adultery, maybe there's been drug use, maybe there's some challenges to the marriage and someone wants to leave, but they'll say, all right, we'll give one more shot. But if not, I want to avoid a divorce. But it's the same series. You're still trying to decide things now, not later.
When you're going through the divorce,
Mm-hmm.
you mentioned that there's lower legal fees, right? That it's not as contentious because you agreed to it previously. Would you compare it to, for example, having a will versus dying intestate, where in terms of how long it takes with the court?
It's a great analogy there, but it's probably even worse than that. But yes, that's a great analogy. You're choosing how to dispose of your assets instead of allowing it to be done pursuant to the law. And the other thing that you save money on, a lot of my prenup and postnups designate who's paying for legal fees. So when it's people on equal footing, I usually tell them they're going to pay their own legal. That's my advice. We've also had ones where the higher salaried doctor, if they get divorced, still has to pay the legal fees. But this way, we don't have to fight about who's paying legal fees. So what happens is in the beginning of a divorce, if you have a premarital agreement, you have 30 days to basically move it to court that it be included, or then the other side could challenge it. I usually put in my prenup post office. If the other side challenges and loses, they got to pay legal fees. The language in that post number prenup, that's essentially going to be converted into your judgment of divorce as it relates to whatever terms were there. And then we can move on to any terms that are remaining with the court, whether it's child support custody or whether maybe you didn't waive alimony, you want the court to decide. I usually tell people to define the alimony, just avoid the trial. And you can do it by schedules. There's a lot of different ways to do it. And in the end, this is all math and figuring out fair ways that both parties are comfortable with that they'll be provided for.
So to your earlier point, you get the prenup, you put it in the drawer, you forget about it, right?
Yeah.
Your life changes dramatically over 15, 20 years when you go into the divorce. How applicable is that 20-year-old document to your current circumstance?
I had a law professor who said that the New York State courts are in lust with enforceable contracts. That's not in the law. And the New York State courts want contracts to be enforceable. Like I just hope every state does, because if contracts aren't enforceable, it's the bedrock of our society and our economy. So there are protections if a contract was done under duress, fraud, but for the most part, they are enforceable. The unfortunate times I see them not being enforceable are when someone brings me one that they did on their own, and it's not acknowledged in the form that you would acknowledge a deed. So simple, right? Maybe it's a regular note, notarized. That's it. End of story. There's no way of helping. That document is worthless. That I see from people that went to a bad attorney or went on the internet and did their own print. It's worthless. But the document is fully enforceable under all the same general theories of contract law, unless there's a reason that it's unconscionable. But unconscionable is not what the client thinks when they come in, that they're getting nothing. It's really based on the circumstance of when they signed. And you can look at the current circumstances as well. But that's why I put in to my prenups and post-nups that if you challenge it and lose, that you have to pay my legal fees.
And of course, if neither side wants to say, all right, this doesn't apply to us anymore, they could just not use the agreement.
I had very recently. I did the prenup. It was like 60 pages, right? Both parties had a lot of small LLCs. They were controlled then. One was a foreign national. And they came to me 2 years after the marriage. And they said, I said, what do you want? And they said, basically, with the terms of the prenup saying, we want each party to keep their own thing. Just because I said, why don't we do this? We're going to have two documents. We're going to cancel the prenup, document one, and then contemporaneously, you're going to sign a second document, waiving all rights, equitable dispute. And the reason I did it that way, it was just a lot cheaper and faster than going to the court and taking this huge document. And at that point, you have to do it in the court. When I say in the court, getting a judge involved. So that's what I do. And then the simple answer to your question, any contract can be canceled by the party by the same theories of contract law. When I do it, I have both parties sign, I have it notarized, and it literally just says that we hereby cancel this prenup. I always append it. And this way, now they can go into a divorce as a true, no fault, uncontested divorce, and we can do it without a settlement agreement, and it's quicker and saves money. That's not appropriate for everybody. For some people, they would want it. Maybe they have partners. They may we want a detailed judgment that says wife has waived her rights to this. But for some parties, it's not necessary. So it depends. The answer is yes. You cancel your prenup.
Then, of course, obvious question, or maybe not obvious, but the following question is, in what scenarios can a prenup be tossed or ignored, or the court saying, yeah, we're not doing this?
So fraud is one of them, duress, and some of the factors that they look to. First and foremost are some common sense things like, are both parties represented? They're going to look at that. It doesn't mean that if you're not represented, you're pro se that it's not enforceable, but it is a factor. The wealth of each party, what each party knew. I was reading a case yesterday, and it was talking about that there actually is, in fact, a duty of good faith to your spouse, which I never really thought of it that way, because all I deal with spouses are lying to each other, but it doesn't matter. But things of that nature, if you misled the other side and not just not telling them about the assets, it's making them believe they don't exist. So you don't have to have complete full disclosure in the prenup, but you need to be pretty clear what's there. Those are some of the factors. And one more factor.
Go ahead.
Language. The person who signed the prenup signed it in the language they speak. Because I also see prenups from, and it's usually men, wealthy men who bring over a female bride from another country. They bring them here. They have them sign some comprehensive prenup. These people are not represented by attorneys. They signing it in a language they don't know. It's that to me would certainly be a great factor to overturn. And these are things that I've seen, that I've done, and or I've clients want to do it. I said your spouse needs a translated, right? And she needs an attorney. And he's, why can't I translate it? I'm like, why can't we use Google Translate? I'm like, you're doing, you want this to be enforceable.
Right.
And, spending a little bit more money on legal fees. And the person, the bride doesn't have to be on paying for legal fees. My client can pay for her legal fees. She just needs an independent counsel.
What about in the scenario? Again, we're going back to the medical space. Yeah. You initially sign it. A doctor's in residency, and the spouse is maybe working as, I don't know, marketing or banking or something in that space. And then they have kids, and the kid stays home, and what they agreed to in a prenup, maybe in a prenup they weren't planning on kids, and then they decided to have kids. And then the prenup is very heavily favored towards the more asset spouse or the higher income earning spouse. And then the other spouse during the divorce is, look, the different circumstances, like, this doesn't apply to our life now. And one spouse wants to push it to be enforceable, and the other spouse doesn't.
So usually the person who's taking care of the child, a non-doctor, they are protected in some other way. So we first look at what's still available to child. And child support, again, another formula, it's 17% of your adjusted gross, but this is a Child Support Standards Act adjusted gross. You're not getting credit for your federal taxes or your state taxes. You're getting credit for your New York City taxes or Yonkers taxes, your local taxes, your Medicaid, and your Social Security taxes, which is roughly 9 or 10%. If we're looking initially at $1 million earner, take 10% off the top. He has $900,000 left. But child support also has a cap, and it's the same confusing way they do it in spousal support.
So I guess, like normal contracts, right? Mm-hmm. There's a severability clause. And the severability clause says that if any parts of this contract are illegal, especially in things like management service organizations or other healthcare entities structured contracts, you leave the severability clause in saying if one part is not enforceable, then the rest of the contract is still enforceable. So you can pick and choose what's enforceable or not. The court can, rather, not you. Does that apply?
It does. So all of our prenups, post-settlement settlements, agreements have severability clauses in the event that a certain provision is deemed unlawful. It won't affect the rest of it. So yeah, we also have that. So yeah, so one part was deemed unlawful, that would now then be an issue for the divorce judge to decide. So yes, certainly. And there's exceptions to that in my agreements, because sometimes some of the clauses, whether they're legal or not, are could be, or it's so interdependent on another clause. We'll put that with the exception of this clause. Let's say you're giving me $100,000 in return for me giving you a house. If it somehow turns out I can't give you the house, no, I don't get to keep the $100,000 too. So there's exceptions to that. And so at least in my, but yeah, we have the standard severability clause that we have in all three. But it has not happened to me. And every time they update the DRL, it's perspective. So for instance, don't get me wrong, I think it's 2016 when they changed the DRL as to enhance earning capacity. It only applies, and as it applies to the medical license. When they made the law, it applied for cases filed after 2016. And I've had cases where they changed the maintenance statute in the middle of the case. And it'll say very clearly, this applies in cases commenced after this date. So if you have an active case going on before that date, you go with the old law. Now let's go after divorce. You have an agreement or you have a judgment and a trial. There's still things that can be modified.
Big concern for medical professionals, doctors, or someone in the medical space, or whatever it is. They don't have a prenup, and they don't have a postnup.
Yeah.
And
they're not getting a postnup, because most of the doctor's spouses are smart enough not to sign it unless they think it's best for their family. They might, but a lot of them would recognize that whatever they sign will limit their right somehow. But again, I've had ones where they signed it fully understanding what they're doing, and that's perfectly fine too. But mostly, I would say that it would be hard to get your spouse, the non-doctor, particularly a stay-at-home spouse who's raising the children, to sign a post-op.
Okay. So what can a medical professional look forward to in a divorce? Talk to me about where it's less contested and everyone just wants to do everything fairly versus when obviously we've all heard and seen wars.
I try, and to the best that I can, to bifurcate all the issues, which the court tries as well. So I try to negotiate the assets, and that's first. When we're doing an agreement, but custody things on their side, there are going to be emergency issues that may come up, and we'll deal with them. But there's no advice I can give to a client based on mathematics saying that you should settle custody because it's going to cost X amount of money. It doesn't compute. If you love your child, you're going to spend whatever you can. Now you can take in consideration, hey, we're wasting the child's college fund here, but it's the same when I'm talking to a client about, this is the assets I see. This is what I think a judge is going to order at the end of a long, costly trial. So let's try to get that half of that number in value. So when it relates to doctors' businesses, I try to look, we have any other lawsuit. We have a preliminary conference and we have voluntary, compulsory exchange of documents. And then we have a schedule for further document demand definition. I try to, as quick as possible, get everything we have to the other side, vice versa. Even you can't necessarily evaluate a company based on bank statements and based on purchase agreements, but it's something. And I try to, as quickly in the process, get an outline of what the value of the assets are. So then we can find something to give the non-doctor spouse. And sometimes you can't. Something has to be sold or a promise needs to be made that I'm going to pay X amount of dollars. But that's what I try to do first. And then I'm not a business evaluator. I don't have a degree in finance. So I'm doing this to the best of my ability, but we always hire or have the court appointed appraiser. There's ones that are accepted by the first and second departments is a list. We can choose one. And whether we go that route depends on what the business is worth and how contentious the arguments are, because those can also cost a lot of money. It could be $25,000 retainer, which may be worth it if you're evaluating $1 million business that one side says is worth nothing, but it may not be. So I always try on my own to do things more efficiently, but like every case, we slowly ramp up the discovery demand, slowly ramp up the motions to compel, then the business evaluators.
Are there depositions?
Yes.
Okay.
But the depositions are limited to what we're talking about. There aren't depositions on custody.
Sure.
A lot of people know that.
Let me ask you this. Medical space is an interesting thing, right? So right now in the insurance environment we're in, a lot of medical practices face billing audits. And as a result of those audits, there's overpayment determinations that go to the appeals process. So a medical practice can be ordered by the federal government to repay $10 million. Is that at all taken into consideration either during kind of the divorce proceedings, the prenup, or, for example, after you already have a judgment or a settlement agreement after the fact?
After the fact, unfortunately, once the equitable distribution is final, it's final. The court's not going to get into it. There's a lot of case law on so if one spouse paying the other money, it's called distributive reward. There's a lot of case law that it's final. You made a decision based on the information at the time. And no, you can't modify that. That's not to say you couldn't in an agreement in anticipation of that. If you were the doctor and knew that it's a potential thing, you can negotiate some sort of clawback in the event that this happens. Or I'm not saying the non-doctor spouse will go for it. You could say, I would like to delay this payment until that. I don't know how uncomfortable I would be with that, because I do really want these agreements to be final. But when you're talking about the hypothetical audit, if the audit has already started, then that issue cannot be settled until it's resolved. It could be anything settled on both sides. If I was the non-doctor spouse, we're talking about like a $10 million audit. That's a lot of money going either way. And it would be hard for me to settle a case. I think that it would be hard for a court to try a case until that is resolved. Now, I haven't had that issue go in front of me. It's an interesting issue. And that perhaps that should be in a prenup for doctors.
Yeah, so it applies to doctors, but it also applies to pharmacy owners, right?
Yeah.
In the pharmacy space, because pharmacy benefit managers, which I talk a lot about, constantly auditing pharmacies. And it really impacts how much a pharmacy makes in terms of those audit findings and even spending money. And, when you have a $10 million audit finding, right? Like there's spending money on legal fees to even revert those findings, right? Sometimes you're better off paying $1 million to an attorney to get rid of a $10 million finding.
Yeah.
So that really changes the economics of the family.
All those expenses are reasonable expenses that would reduce the income of the business for that year or reduce the assets of the business. It's not a carve out, because if we're talking about a marital asset, business spends what it spends. And if it has to pay back $10 million, it reduces the value of the business, or the $1 million in legal fees. But those would be reasonable expenses to be paid.
But it wouldn't matter after the fact, after like post judgment. Like, for example, a pharmacy, right? If they're terminated from a major PBM, might as well shut your doors. Are you still supposed to pay what you were making during the heyday?
Unless you agreed to some sort of clawback or some sort of provision, it's final.
So I think that's a major consideration when negotiating the prenups and the post.
If you're on the doctor's side, but you certainly, let's say you don't exclude the medical practices, that you include some sort of protection in case of an audit, that if you're going to pay out based on this valuation, that you can get it reevaluated. Because it's contentious, the clause, and I'm just making this up now, you could probably have a clause in there that I suppose, I don't know if you're happy with this, that you can reevaluate the business post-judgment. Because you're saying it'd be changing the circumstances. But I don't know how the court would like that, but they really want things to be final. And I wonder whether the business evaluator has a mechanism to bake that into their initial evaluation, to say, if there is an audit, this should be greatly reduced. Because if you did an audit of business, I would think it would be in an audit report that the potential risk coming down. But that's a really interesting question, and certainly should be considered.
The other interesting question that piggybacks on that, right? Let's say you don't own a medical practice, but you're a fantastic doctor at a huge hospital or provider group, but you're an employee, right?
Yeah.
And you have a great salary.
Yeah.
What happens if you lose your license or your license is suspended to practice medicine for whatever it is, right or wrong? Obviously, sure, there's an appeals process, but again, how does that impact your ability to pay?
If we're talking about a distribution of an asset, again, it's still written in stone. The child support, you can go back and modify it. I caution people though, if you lose, but here's the problem. If he loses his medical license, it's based on cause, right? And if it's based on cause, and this might be unfair, it's very hard to modify your child support obligation. The only time you can is if you lost your job through no fault of your own. And even then, the court expects you to go out and find another job. And I've represented people like this, and I tell them that when coming into my office, I want you to send out 100 resumes on Indeed or whatever the popular service is, and I want you to go on 100 interviews. And God willing, you can get a job. But if you don't, I can show the judge you're trying everything. And even then, the judge may question why this person can't get a job. During COVID, judges were more sympathetic for a period of time where they recognized, okay, maybe we're going to temporarily pause child support payments. But at the end of the day, it's really hard to downwardly modify when you're fired for cause. And then here's the other hypothetical I see. People quit their jobs and they think I quit my $400,000 a year job. Now I don't have to pay child support. They do this during a divorce. They do this after the divorce. It's not how it works. If you quit your job or you're terminated for cause, it's very hard to modify down. And people do this. Maybe they weren't being nefarious. Maybe, I don't know, but they get a lot of bad advice.
On the medical license side, there could be a lot of situations where they don't get the right guidance or something else where it wasn't actually their fault, but their license is still suspended because numerous factors that can come into play. Is it the court's position that too bad, figure it out?
I've certainly heard that verbatim from judges in the family court and the Supreme Court. But yeah, or you have two arms and two legs. And the mistake a lot of people make who do make $400,000 a year is that if they're offered a job for less, their pride won't allow them to take it. So my advice to my clients is take the cheaper job and we'll figure it out. Still apply. But what happens is people refuse to work. And if you refuse to work, last week I had a judge essentially tell someone who wasn't working and said they couldn't get a job, McDonald's is hiring. That's not practical for doctor, but you have to do everything in your power. You can never tell the judge, I didn't do it because I didn't want to. You have to try your best and do things you don't want to do to get the judge's attention. But then all these other issues of fraud and whose fault it is, it would be subject to a motion and most likely in this case, a hearing. You'd have to have a hearing. You probably have to get experts in about what this person's ability to earn is, because the law is based on your ability to earn. Now, for 90% of the population who is a W-2 earner, your ability to earn is what you take home. But for a lot of people, it's not, because you're self-employed, you play around your income one year, goes up the next year, or you choose not to work. So then we have to look at your ability to earn. And look, there are sad stories. I've represented executives that have had nervous breakdowns working 100 hours a week, and they literally just couldn't do the grind anymore. And they went and got a job as a high school teacher because they just couldn't do it. And the judge can't force you to work, but they certainly can say, I think you can make that. I still think you can get that job as an executive.
That's crazy.
I'm charging you child support based on the $400,000.
Wow.
Not based on the $80,000. And probably the reason the judges feel this way beyond the law is there are a lot of people that try to take advantage.
It's tough.
It's
tough.
Definitely. But I've had situations where it's hard for businessmen because it's hard to establish where they lost their business in COVID. They've been businessmen for 30 years. What are they supposed to do? They're supposed to, they ran a restaurant for 30 years. They have no capital. What are they supposed to do? Go back to school? It was facetious to say to go work at McDonald's, but they probably have to get a job as a waiter somewhere.
That's nuts. Wow. This has been great, man.
This
has been absolutely great. It's fascinating. Any parting words? Anything you want to leave? Any kind of parting message?
Just the general idea that information is very helpful to all parties. And when the doctors are forming their LLCs and their businesses, they should ask their attorney then about this hypothetical. If I needed to sell my shares or my units in this business, could they be sold to a non-doctor? Just simple questions to find out. I'm not saying don't invest in a company. I was making investments based on what's going to make you money, but just more information. And listen, doctors are very analytical, smart guys. And sometimes they're too busy and they're handling too many things, but they certainly have the ability to process this information. And the non-doctor spouse should be asking about it. That would be the key information. Even if you're not planning to get a divorce, you should at least talk to a divorce attorney just so you understand in the broadest of strokes. What are the possibilities? Because although you should never stay in a bad marriage, you should at least know that when you get out of the marriage, what your life's going to look like. Because most people have a big misconception. And it seems to be the people that have come to my office, they all think they're going to come out of a marriage destitute and broke, or they all have the misconception that they're going to win the lottery. And neither is true. So speak to lawyers and people that know what they're talking about. Don't take advice from your family and friends, and don't Google the information.
That's, I think, the best advice there is. Just don't Google this kind of life-altering information. How can people get in touch with you?
Sure. My office number is 646-559-6735. We're located at 299 Broadway, Suite 203, New York, 10007. We're about a block away from the New York Supreme Court and 2 subway stops from the Brooklyn Supreme Court, where most of our practice is. And my email is Michael, my first name, at Mueller.law. The URL is MEULER.LAW. I just want to congratulate Steve on his podcast. I watched the first 2 episodes. I think they're great. And I really hope that the viewers enjoyed this. And I hope they reach out to us if they have any questions.
Absolutely. And I'll also put Mike's information in the description, as well as your socials, right? People want to get in touch with you. I'll put those in as well. And any specific questions, or if you want to attract any attention or highlight any part of the video or the conversation, just leave a comment and we'll try to get back to it.
And I guess we should add, we really enjoyed this, but none of this can be taken as legal advice.
Absolutely. None of this is legal advice.
Hopefully you will call us and we can give you something.
Absolutely. Purely educational. Thank everyone and have a wonderful day.
Thank you.